Georgia SB 189 does two things. First, SB 189 allows private individuals to challenge a voter's qualification to vote on the basis that they live at an address that is quote unquote non-residential, including unhoused and housing insecure voters, students who might live in a college dormitory on a college campus or university campus that is zoned as a commercial or institutional zoning and therefore non-residential, people residing in nursing homes or shelters or transitional housing, addresses that are 100% valid to be registered to vote at. And yet SB 189 provides that they can be challenged and potentially face their ballot being not counted or being removed from the rolls on the basis that they live in a quote unquote non-residential address. These are challenges made by third-party groups, activists, individuals, private citizens, and increasingly has been used by anti-voter activists in Georgia and elsewhere around the country as a way to remove voters who they have information that they believe suggests that the voter may not be eligible, but is often based on faulty data, outdated data, and faulty methodologies. The second thing that SB 189 does is it requires voters who are quote unquote homeless and without a permanent address, so unhoused or housing insecure voters, to use as their mailing address for voter registration purposes their county registrar's office. So these are voters who already are having difficulty with their residence, difficulty receiving mail related to that. Their preferred address, mailing address might be their shelter where they're staying, or a church that they're working with, or a friend or a relative's house where they know that they can reliably receive mail. And this one class of voters, unlike all other Georgia voters, must use as their mailing address the county registrar's office. This is a heightened burden for people who are already the most marginalized people in our society. Georgia's history of racial discrimination in voting is dark and well documented. And Georgia has been one of the worst examples of state legislatures passing new restrictions to voting that are simply not justified by any compelling state interest, any even reasonable state interest, and have the effect of making it harder to vote and disproportionately disenfranchising Black Georgians, other Georgians of color,